Now turn to the next case on this morning's docket. That is case number 107556 in the matter of Stephen B. Small, respondent. Mr. Small was not present at 9 o'clock. Is he in the courtroom at this time?
I am, Your Honor, and I apologize to the court. I've had some rather bad health problems in the last 7 months with the herniated disc, terrible sleep apnea, and a new changing machine, orbital tumor removal from my head, general anesthesia. It just was running a little bit late. I had to move all these boxes home, and it's a painful problem with moving the file around.
Very well.
I apologize to the court.
All right. Thank you.
Thank you, Your Honor. I did have one request, and that's leave to make a preliminary motion to dismiss on grounds
Counsel,
of jurisdiction.
you'll get a chance to talk about that when it's your time. We'll first hear from the disciplinary administrator. Thank you.
May it please the Court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, I ask for 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. As the Court is aware, by order dated October 22nd, 2012, by Mr. Chief Justice, that this matter has been submitted as uncontested, and the findings of the panel that Mr. Small has violated 8.4D and G are submitted to this court. I would note to the court that the pattern of conduct does continue since the final hearing report. For an example, if you review the August 30th motion for the extension of time to file a brief, the respondent continues attacking the process, the attorney investigator, the disciplinary administrator, and his former client. I would further request that the court carefully review the concluding paragraph on pages 9 through 10 of that pleading, wherein the respondent argues that this proceeding and recommended punishment is actually infringing on his religious freedom. The panel recommended a 90-day suspension. In the closing pleading that we were required to file, I noted that my belief was and always has been that there needs to be an evaluation to determine why the respondent engages in the conduct that led to the panel recommendation for suspension. The respondent did not file a plan of probation, and so that was not and is not an option for this case. I agree with the panel's recommendation that suspension in this matter is appropriate, but based on the continuing conduct, I believe that suspension for a period of 1 year is more appropriate. But more importantly, I request that this court order a reinstatement hearing pursuant to Supreme Court Rule 219 with a specific request that there is an evaluation from a provider approved by KLAP and a detailed plan for some sort of practice supervision should the court adopt those recommendations. I don't have anything further unless there's any questions.
Any questions? Thank you, counsel.
Thank you.
May it please Your Honors. I've been an attorney now for 27 years and never the subject of a proceeding such as this, never subjected to formal discipline. When I took the bar exam and the ethics rules said we had a duty to zealously represent our clients, and I try to do that within the bounds of the law is how the rule put it. And the bounds of the law include the First Amendment. And my understanding of that is the Kansas Supreme Court interprets it in the United States Supreme Court are that speech that is truthful in pursuit of the legitimate conduct of litigation, that is not discriminatory, vile, threatening, is protected speech, federally, constitutionally protected speech. And sometimes as lawyers, we run into parties or adversaries who just don't play by the rules, which was the case with Mr. Rank. Mr. Rank wouldn't agree to any settings on anything. His clients weren't paying rent. They admitted stealing property. They ex-partied the trial court. A TRO was granted on a Friday afternoon to get these people out of this lady's house. They had threatened to throw out all of her property. It was about a $700,000 to $800,000 house in Leawood. $500,000 in contents. They stole the plasma television sets out of the wall and couldn't explain where they went. They were selling things on Craigslist, wouldn't pay the rent, wouldn't change the utilities, made all kinds of demands, told her, if your stuff isn't out by 5:30 on Friday afternoon, we're putting it out. I get her on Wednesday. Now, I don't really know her. I knew her husband. He managed a TV station that had hired me years prior. We had a good relationship, and, you know, if you need help, come in. Let me call this guy. See if I can fix the situation for you. The man was out of control, and so she had three choices. Hire a landlord-tenant lawyer close to the courthouse for a little bit of money. Her preference was maybe to do nothing. And then I said, well, you know, maybe we can get a TRO. Because under the law, you have to give 3 days written notice before you can file an eviction action. I can't just go out to the courthouse and get them evicted. So equitable relief under the egregious circumstances seemed to be appropriate. This lady, unbeknownst to me, had just been convicted of felony identity theft. She was a realtor. She lost her license. She stole her employer's credit card. She went into a house and stole a credit card and went shopping at Nordstrom's. She misrepresented all of her means, and she got me into this case. No cooperation from the other opposing counsel. And, you know, the rules talk about expressing our approbation or lack of approbation, I guess it means approval, freely with our colleagues. And to suggest to Mr. Rank, how can you allow these people by, you know, delaying this, to stay there and continue to harm this woman? I couldn't do it. I would think you'd have to withdraw. One of Mr. Rank's tactics was to threaten me and my client with a lawsuit for stealing from this house. Now, I'd been in the house for a few minutes when the police escorted Mr. Bloom and his wife, or Mr. Bloom was there, out. I didn't steal anything from anybody. And so I let him know, you know, if you do this, you're going to have a malpractice risk because your clients are going to get sued. You're going to create risk. He never sued us. I mean, sometimes you have to express yourself and think the thing through and say, look, do you really want to play this game? Because here's what's coming next if you do. And I don't think that makes a person emotionally unfit or unfit to practice law. Judge Sutherland, the prosecutor made a point of saying, you know, you wrote this email to Judge Sutherland. Judge Sutherland on Monday morning called me and he said, left a voice message at 9:30 or so, and 5 minutes later I returned the call. I feel you misled me by concealment of the fact that people were operating a business in this house. Get down to my courtroom. The tenant's very angry. Very politely I returned the call, Your Honor. I didn't know they were running a business in this house when we filed this case. It's a residential-only lease. They wrote the lease, the tenants. The land use restriction doesn't permit any business use in this area. The city wouldn't give him a license, and the guy claims to be an engineer, but he doesn't have an engineering license. So these are all, that would be something else I would plead had I known it. I'm not concealing anything, but we'll be there. This judge his mind was changed by the ex-party of the tenant that morning. And, you know, he told me there was ex-party. And I thought, you know, this fellow Bloom could just, you know, walk into the courtroom and assault the judge with a bunch of comments or questions and concern him. I don't think that was a matter of judicial unfitness. I didn't think that I had to file a complaint, but I felt that the judge's mind had been poisoned by this ex-party and recusal was necessary or disqualification. Now, there's a fundamental problem with this case, and before I really get into these various and sundry allegations, your rules provide that there must be a probable cause finding, Rule 210E. And during a hearing on November 4th of 2011, Ms. Knowles stated the following from the record: I don't believe there's a probable cause finding. Even if there was, that time has passed. I don't believe that I or anyone associated with this office violated any other rules of professional conduct. Now, why would a lawyer spontaneously make a statement like that? If there wasn't a probable cause finding, she had a duty to tell the court that. She had a duty to tell the panel that. She had a duty not to file this case. Prior to that, Mary Friedheim ran up a bill of $32,000 which the panel determined was not unreasonable. The work was done. The rates were reasonable. There was preparation for a mandamus action in this court. In connection therewith, there was an affidavit in support of it to disqualify this judge from further proceeding. And the time was spent. In fact, 117 hours were spent and 99 were billed. She wasn't overcharged. They don't have a problem with that. They also exonerated this charge of Rule 1.6, violating confidentiality. I violated confidentiality, allegedly, because I sent statutory lien letters to the insurance company, my client's insurance company, who was at risk for all this property damage, and to the tenants' council. And they were nothing more than, I represent so-and-so, I assert my lien, the amount is so much, when the case is resolved, please protect my interest. No attachments to them. But yet the prosecutor marks as an exhibit the blind copy to the client, confidential information, and says in her complaint, I sent that to the insurance company. She's got an investigative report that says I was minimally cooperative because I failed to produce an index that I volunteered to make myself. And index the documents, which I did. They were Bates numbered. I said, I'd like to meet with you. I've got 800 pages here. Let's talk about what you're worried about. And it was sent to her on February 20th of 2010. The bar complaint was in response to a fee suit being filed. There's allegations in the complaint that the client filed a pro se motion to dismiss the fee dispute, but in fact the record shows we voluntarily dismissed it after she failed to show up for a depot. I'm sorry, I'm diabetic. Can I get a little water? I'm very dry. And so there are all kinds of factually, frankly, not true allegations in this formal complaint. And certainly there could not be probable cause to believe that this lady got this fee case dismissed pro se on a motion when the documents of record show we dismissed it because we couldn't proceed, we couldn't try it. She frustrated our preparation. She moved out of town. And so there's that problem. There's other problems with this case. The purported complaint filed by the client, which was marked as an exhibit by the prosecutor, wasn't what was filed by the client. It was a combination of documents, some of which are dated as a year later than year later than the client's complaint, truly a real estate report. There are allegations that are so preposterous that he notarized the document. I didn't notarize any documents, and I didn't have a practice of getting my signature notarized on a document. The document she's referring to was an affidavit in support of the mandamus application, and it says, actually, it relates to, she thought it was maybe done in October, and there was some blank signature page, okay? What actually happened was it was drafted and completed on the 14th of November, and I think it's on page 9, maybe paragraph 31, it relates to facts that occurred on November 12th. Now, how in the world could I know prior to November 12th anyway what was going to happen on November 12th? They related to filings and things. I mean, this allegation about notarizing things, it's outrageous. Then she talks about altering evidence. By the way, the citation for the November, it's Exhibit 30. It's Bates page number 213, and it's paragraph 31. On November 12, 2008, plaintiff filed a second emergency pleading, okay? And the signature page shows it was notarized on the 14th of November, which must have been the day I completed it, and another lawyer in the office notarized it. And I have an affidavit. I wasn't allowed to call any witnesses in my behalf. I wasn't allowed to put on any mitigation evidence in my behalf. The way it worked was Mrs. Knoll scheduled this for a one-day hearing on October, back in May, didn't file the complaint until late August. Then when we, filed my motions and things that I felt were necessary, it's an adversary system. Parties are free to assert their positions and raise their disputes. And there was a lot to dispute by nature of the conduct that I was being subjected to. So anyway, she then threatened my lawyer, and I have a letter. It's not of record, but I think it's relevant to her argument about, continuing things after the formal complaint. She says she's going to raise this issue of mental competency because her interpretation of some colloquy we had on October 4th was that I accused her of wanting to suspend me or something. And what I actually did was I related my understanding of what the investigator's recommendations appeared to be. And the investigator said something like, well, I'd recommend he be suspended, but he's never been disciplined before, so some lesser thing, maybe reprimand or diversion. Now, the exhibits that they talked about, fraud on a court is a very serious thing. The last case was about fraudulent representations to the court, okay? And here you've got representations that I have done things I have not done that are unsupported by the record. Now, I've been very sick the last 6 months, and I've had some interference from a Johnson County disciplinary attorney by the name of Nancy Wilson, who's tried to wrongfully foreclose my home. My home is a large Victorian home in Hyde Park. It had storm damage. The insurer said they would repair it. They didn't get it done. It's full of toxic mold. It's been in litigation for years. So the mortgagee commenced force placing all kinds of charges for insurance on a house that's uninsurable, that they had a very little, maybe less than $80,000 interest in, if any at all, for $854,000 at $34,000 expense. In Missouri, you can only insure the loan balance if you're a lender. You can't charge 11 times. Well, that's what they did, so that was the basis of her conduct. And a complaint was actually filed, to which Miss Knoll, early in the briefing schedule, said, I'm going to put this in your file. In other words, deprivation of the protection of the law. Here, I'm being threatened with being forced into bankruptcy to stop a non-judicial foreclosure for money I don't owe. And the policeman who's supposed to keep lawyers from behaving like that is telling me, you're going to get it for mentioning it to me. I thought we had a duty to notify the court if there was a problem with a lawyer, and that's what I did. But these exhibits, she says, were altered. They're emails. And they're not altered at all. What happened was in 2009, I tried to print out the emails, and AOL at the time was kind of primitive in this capacity. They came out very small. For example, Exhibit 106A is an actual screenshot of an email. I couldn't read it. I'm in failing vision. And so I cut and paste these things into word processing. And I put them all together in a file for Miss Pearman, the investigator. I had them bait stamp numbered. This is the exact same language with the addition of simply highlighting in bold and black. I don't have a color printer, so I could have done it in yellow if I did. Maybe that wouldn't have been offensive.
Mr. Small?
Yes, ma'am.
Right here.
Thank you.
Could you address sanction? Because you're short on time, and I
Yes,
don't want
I
you
think
to
the case-
sit down without being able to tell us your views on sanction.
I think that this case is a retaliatory case by reason of the fact that of one simple thing. When I got the investigative report, I read it, and I said, look, you say there's probable cause that I violated 1516, 82, 83, 84D with respect to a letter that was written to another lawyer. There was no 84G pled at all. There was no allegation that 84G was found as probable cause. There was no notice of it. And I don't think
Counsel, your 15 minutes are up, so I'd like for you to answer Justice Byers' question, which is, what is your position on sanctions? Should any be imposed, or do you agree with the disciplinary administrator? Where are we on that issue?
My position is this, Your Honor. I did not intend to concede anything. I have been through surgery after surgery, and this thing is so complicated by reason of the way it was prosecuted that I would like the opportunity for the court to be fully informed. I mean, the prosecutor forced me into bankruptcy. That's what she did. She forced me. There was litigation pending. Then this formal. Then we had the hearing. Then my house litigation. Then we had the report. Then we start with the foreclosure business again. And I'm trying to get this done. Then, as soon as that happens, I herniate my back, and I'm on oxycodone around the clock for a month and a half, maybe longer. I go blind in my eye. I have a picture of the tumor, if you'd like to see it. I have the operative reports. I even have a description of the surgery. I mean, I have been through the worst health year in my existence. Never had general anesthesia before.
My question, sir, is what should we do about discipline?
Well, okay, so I guess my answer is, your answer to me is no, we're not going to let you file a brief out of time, and I would move to do that so that you could see why discipline should not be imposed. These allegations are seriously at variance, and findings are seriously at variance with the rules that govern our profession and unsustainable. I mean, if one were to read these, like, look at these exhibits, they'd say, this guy didn't alter these exhibits. He didn't notarize that document. Where do you guys come up with this stuff?
Just so I'm clear, your position is that no discipline should be imposed whatsoever. Is that right?
My interpretation of the APA...
Is that right?
My belief is under 210E, I believe it is, or C.
Did you answer my question? Do you believe any discipline
I do not believe it should, but if the court believes it should, my feeling about it is this. I have never been subjected to discipline before in 27 years of practice. As a licensed stockbroker, commodity broker, realtor.
And if we should impose discipline, what should it be?
I think it should be a private admonition is what I think it should be, and let me say why. I did not cause my client any harm at all. She got the people out of her house. She got money from her insurance company. She never paid me a dime. She was happy. She sent these emails telling me how happy she was. I did not cause harm to Mr. Rank, the opposing counsel. He had no right to make these allegations. Simply confronting him with a response to that, not violently, not profanely. Here's what you're doing. Please try and cooperate. Stop doing this. That's not misconduct. Judge Sutherland says in the hearing, I'd do the same thing if I was you. He didn't make a complaint against me that I'm aware of. He's not mentioned here in any way. He was, it took us a month to get the case resolved, but I felt, this judge offered to give us a hearing, and I really didn't want to, take issue with it, but there was prejudice. I had an obligation to my client, and that's privileged communication under the recusal rule. The lawyer has to state the factual basis. No court shall find you in contempt for filing an affidavit in support of recusal. And in terms of Ms. Knoll and Ms. Pearman, quite frankly, these things were not charged in the formal complaint. That if I filed an objection or a motion, that I was notified that I would be disciplined for simply representing my own interest in the case. I mean, this 8.4D and G were not pled sufficiently to even, how can you be charged, how can you be convicted of something you weren't even charged with? And then how can you even proceed on a formal complaint in the absence of a probable cause finding? Now, she writes a letter and says, we found probable cause for all these things. None of them were found. None of them were convicted. And she admits there was not probable cause. In the absence of probable cause, the court should dismiss this case, strike this pleading, this panel report, and seal this record. Here's what I asked for, and here's where things went wrong.
Counsel, the question that I posed was, if discipline should be imposed, what is it? You've answered that question for me. Thank you. We're well out of time.
Thank you, Your Honor.
All right. Thank you. You had requested 3 minutes for rebuttal time.
I just want to make a few things clear. I know the court has the ability to review the entire record, and I know that will be done. But there were probable cause findings for the 1.5, which was charging $32,000 for basically 6 pleadings and 3 court appearances. The review committee did think that a panel needed to take a look at that. Yes, the panel did not find that was a violation because Ms. Friedheim was, as they described, a very needy and kind of an assertive client. 1.6, the letter that was sent to Ms. Bell Lloyd, there was a finding that under the Bryan case and some other cases that was something that a panel needed to look at. And the panel concluded that that letter, while unnecessary, did not rise to the level of a 1.6. What I was talking about regarding the probable cause was the allegation determined by the investigator that there might have been a violation of 8.2 for the document prepared regarding Judge Sutherland. And it was determined that because it was not presented publicly or filed, it was just in his file, that that did not rise to the level of 8.2, and there was no probable cause finding, and that was never charged out. And the discussion that he was reading, Mr. Small could not seem to grasp the concept that that was not on the table, that that was not part of it, and we spent a tremendous amount of discussion about his defense to that when it wasn't ever going to matter. And I did not threaten, but I did inform his counsel that he had for a brief period of time that based upon his conduct in the very first hearing on for the continuance, that I believed that there might be a competency issue. I could not figure out what was going on, but as I think the court has been exposed to, there's something about his approach to the practice that is unorthodox, to say the least. And finally, I did correct the record regarding the dismissal on the ex parte. The panel altered it. It was my mistake. I apologized on the record. I admitted that I misread the documents, and so that was also corrected.
Any further presentation?
I do not.
Any more questions of counsel? Thank you, counsel. Thank you
Your
both
Honor.
for your arguments this morning. The court will take this matter under advisement. That concludes our docket. Court is now adjourned.